Hello, everybody, and welcome to Lecture 3 of Elements of the Law of Contract. As we discussed earlier, we are going to continue with offer and acceptance. And last week we discussed and we tried to differentiate offers from invitation to treat, and we also tried to identify offers, and we tried to identify the acceptance and then differentiate acceptance from counteroffers. So once we have ruled out the possibility that a purported acceptance is in fact a counteroffer, we must then ask whether it conforms to the general rule that acceptance must be communicated to the offerer. So that is our general rule here, that an acceptance must be communicated to the offerer. Okay. Since it's a general rule, there are going to be, of course, many exceptions to it. And the leading case for this general rule is Carlin versus Carbolic Smoke Wall Company. And the words of the ruling were, as general proposition, where an offer is made, it is necessary in order to make a binding contract, not only it should be accepted, but the acceptance should be notified. In other words, it must come to the offerer's attention. So there is, of course, a lot of case law on this general rule, and also that some exceptions to the general rule. And to make sense out of that case law, you must recognize that the courts have manipulated the concept of communication, and they have developed technical rules to determine whether a particular acceptance has been successfully communicated or not. In some circumstances, the courts have discarded the rule completely and allowed an acceptance to be binding without communication. Let's look at, I hope everybody is able to hear me. If there is any problem, write it in the chat box. Okay, so now let's look at a different type of communication that we are going to discuss. And then side by side, we will also see when is this general rule discarded. In what type of communications is this general rule discarded? Okay, so in other words, what are the exceptions to the general rule that acceptance must be communicated? So communication of acceptance has been divided into two categories: instantaneous communication and non-instantaneous communication. And instantaneous communication has been further divided into face-to-face communication and electronic communication. And the other category, non-instantaneous communication, usually deals with post, like when you post a letter to accept an offer. So in a face-to-face communication, it's most of the time it's very obvious. So you and I are standing face-to-face, and I give you an offer, and then you said, okay, I accept your offer. So it is pretty much obvious that acceptance has been communicated. So, but what if there can be different scenarios, right? What if I was not paying attention when you accepted the offer? Was it, then you have to think that was it reasonable for you to believe that acceptance was communicated? For example, if I did not hear you because I was not paying attention to you, I was thinking about a party that I'm hosting tonight, and I'm making plans in my head, and I wasn't paying attention to you when you accepted the offer, then you will be deemed to have communicated your acceptance. So the courts will think that you have accepted my offer because it's not your fault, it's my fault. I wasn't paying attention. You have to be able to rely on a reasonable belief that acceptance was communicated. So again, reasonable person rule applies here. Okay. Another situation. Let's look at another situation. Now, again, you and I are standing face to face, and I offer you something, and you are, when you were accepting my offer, an aircraft drowned out your words. So an aircraft was flying by and it drowned out your words. In that case, acceptance must be repeated. It was no fault of mine and it was not your fault, but it is not reasonable for you to believe that acceptance was communicated to me. That's why acceptance, those words, must be repeated in order to be communicated to me, the offerer, and in order to create a binding obligation. So that is what was decided in Entors versus Miles. That's a case of 1955. Lord Denning thought that if a person's word were drowned out by an aircraft passing overhead, the words would have to be repeated for there to be an effective receipt and communication of acceptance. All right. So that was the some different situations of face-to-face communication. Now with electronic communication, lots of things can go wrong with electronic communication. So you are accepting my offer over a phone, and the phone line may go dead. Or in the today's world, weak cell phone signals create a lot of problems. So you were accepting my offer, but your voice started breaking up, and I couldn't hear you. So all sorts of things can go wrong in electronic communication. Another problem is that email may be lost in the cyberspace, and yes, that does happen. Or fax machine may run out of paper or an ink. So these are the things that courts have to deal with. But unfortunately, we do not see a lot of cases with regard to our modern electronic communication, such as emails and texts. So there is an argument whether emails and texts are instantaneous or not. So as compared to post, yes, of course they are instantaneous. But there are two arguments. The two arguments are they are available from the instant it is sent. Right. As soon as you send an email, it is available to me. As soon as you send your acceptance via email, it is available for me to see. So in that sense, it is instantaneous. And the other argument is that they only arrive when you choose to access them. So the other argument can be, if we put it in an example, it would be that if you send me an email and you think it's instantaneous, and that you have communicated your acceptance, but I didn't check my email. So some people say that it is communicated when the offerer chooses to read. So in the same case that we just discussed, Entors versus Miles, Lord Denning made a comment and said that if the line went dead when the purported acceptance was sent, there would be no contract. But if it's the fault of the offerer, then estoppel comes into play. Remember, estoppel is a principle of equity, and principles of equity come in when common law is, wherever common law is deficient. So if the offeree, for example, reasonably believed that the acceptance had been received by the offerer, when in fact it had not, then the success of his communication will depend on the fault of the offerer. For example, you send me your acceptance via fax, and I did not refill the ink, or I did not refill the paper in my fax machine. Now, whose fault is it? It's not your fault. It's the offerer's fault. Then I would have been, the courts will stop me or bar me from denying that acceptance was received. And then comes our non-instantaneous communication, basically Postal Rule. This is most of the times this comes in exam questions. So at least one or two questions have this element in them. So this is an important rule. So let's look at the Postal Rule. The cases dealing with acceptance by post, of course, are exception, as you might have studied already, that this is an exception to the general rule that acceptance must be communicated. So Postal Rule decrees that a posted acceptance, when you post a letter for a letter of acceptance, is binding from the moment of posting without any communication to the offerer. So some people say that law here favors the offeree. And let's see how it favors the offeree. So on Tuesday, defendant posted offer letter. Okay, if you look at the diagram on the left-hand side. So on Tuesday, defendant posted an offer letter. On Friday evening, claimant received offer letter and sent acceptance and posted an acceptance. So on Monday, defendant sold his wool to third party. So basically the offer was to sell his wool. So on Monday, defendant sold wool to a third party. On Tuesday, defendant received claimant's acceptance. So here's the problem. So the courts in this kind of situations have decided that contract was made between claimant and defendant, and it was not necessary for defendant to receive claimant's acceptance. Also, defendant was not allowed to argue that acceptance was too late. So this is the defendant tried to argue that acceptance was too late, but he was not allowed to argue that because the acceptance, the court decided the acceptance happened as soon as the letter was posted. Can anyone tell me the name of this case? This is an actual case. Let's see. You can write it in the chat box if you know this case. Okay. All right. It was Adams versus Lindsell. It's a very old case and a very important one for Postal Rule. Let's look at the facts of the case. So defendants, they mailed their offer to sell on the 2nd of September, 1817. The defendant's letter was misdirected and did not reach the plaintiff until 7 p.m. Friday the 5th. Okay. So that night, plaintiffs accepted defendant's offer and mailed it directly back in a timely manner. It was received by defendant on the 9th, but they expected to receive it on the 7th. They didn't know that their letter was misdirected. So they were expecting an acceptance on the 7th, but it reached to them on the 9th. And in the meanwhile, had offered and sold their wool to another person. Plaintiff fleeces. So these were the facts of the case. And the Court of King's Bench upheld the rule of the trial court that when forming contracts by post, acceptance is valid from the time of posting a letter containing language of same. Okay. So here's where the Postal Rule was prescribed. Because defendants in their offer notified the plaintiffs of their term that they would await acceptance in the course of post, they were bound by the terms of their offer until it was accepted or until the terms of the offer had expired. So Postal Rule is one of the biggest exceptions to the general rule that acceptance must be communicated. And as I said, it is often tested in the exam, but you have to be very careful with Postal Rule. It is very deceptive. So here are some exam tips on Postal Rule for you. And do not think that it's a rule and you cannot get a wrong answer. You have to know the limits of this rule. Number one limit is that Postal Rule will not apply if it would lead to manifest inconvenience and absurdity. Okay. So if my offer specifically states that acceptance must be received within 2 weeks, then your acceptance will only bind me when I receive it and not when you post it. Okay. So it should not manifest inconvenience and absurdity. Another limit of this rule is that Postal Rule does not apply to revocations of offer and counter offers. It is very important for you to remember this. A lot of students when they come across the phrase that letter was posted, when they see this phrase in the exam question, they go like, oh, postal rule, let's apply the postal rule here. And they try to apply the postal rule to all sorts of communication. But please remember that it only applies to acceptances. So do not fall into that trap. Examiners sometimes do that. And then if the postal rule does apply, the fact that acceptance never arrived will not normally matter. So, and there is a case on that, household fire and carriage accident insurance versus grant. In this case, it was recognized that this could lead to injustice and inconvenience, but saw no other way of fairly allocating the consequences of the post office's error. Okay, so due to post office's error, the acceptance never arrived in this case. And judges said that it is unfair. It is unfair, but it does not matter. So you have to keep these tips in mind when you are writing your exam and you come across a question that talks about posting a letter of acceptance. So keep in mind and do not fall into the traps. Okay, so here's a summary of what we just discussed. Two types of communication. If you look at the diagram on top, it's instantaneous communication and non-instantaneous communication. So if you look at the left-hand side, the general rules for instantaneous communication is that acceptance must be received, and then they are divided into two categories: face-to-face and electronic. In face-to-face, it is easy, it's quite obvious, but remember the principle of estoppel that we discussed. If one party is at fault, then they would be barred from saying that I never received the acceptance. In the electronic communication, no communication if reasonable to believe that it was not received, and valid communication if reasonable to believe that it was received, and fault of the offerer that if it is not received. Okay, so and then in the middle you'll see email and text. We do not have many cases on this, so this is why there are two arguments, whether they come under instantaneous communication or non-instantaneous communication. And then in the non-instantaneous communication, on the right-hand side of the diagram, you see that there's a postal rule. And the general rule is that posted acceptance need not be received by offerer. Okay, acceptance is binding on posting. So as soon as you post, it is binding. So this section has split communication into, like we discussed, two types, and the courts are increasingly going to have to deal with more modern forms of communication and decide how to apply the existing law. So these are the problems that are faced by the courts in today's world, and you have to write down, you have to argue, bring up these arguments in your exam. The courts may stick with the present divide and weigh up whether the new method is more like a telex or a post, because they have the cases on that discuss telex method and postal method. So they have to decide whether this new method, for example, email, is more like a telex or more like a post, and then apply that rule. And you can do the same in your exam. As mentioned earlier, this approach is problematic because new technologies are most of the time difficult to compare to more traditional ones. So you can bring up this discussion in your exam and then side with one type of the communication and apply that rule in absence of a lot of case law. Okay, so another exception to the general rule that acceptance must be communicated are unilateral contracts. Okay, so unilateral contracts are something like if you fulfill the following conditions, for example, find my lost dog, purchase my product, I promise to do X in return. Okay, and that X is usually to pay you a sum of money. So if you find my dog, I will pay you £100. So Lord Diplock has referred to them as if contracts. So if you do this, I will do this. So these are referred to as if contracts. And he said that in the Harvella Investment versus Royal Trust Company. So the question is that why are we taking our time to distinguish between a unilateral contract and a bilateral contract? This is because the rules of acceptance, of communication of acceptance are different for unilateral contract. Can you, is everybody in a mute status? I think I hear something. Can you, all of you, can you please check if you are on mute status? Thank you. Okay, so the essential point in the unilateral contract is that you, the promisee, must not yourself be promising to perform the condition. For example, you must not promise to find my lost dog. If you do that, then it will become a bilateral contract. So that is the essence of the unilateral contract, that you are not promising to do that act for me. I am promising to pay you if you do X or anything, find a lost dog, find a lost property for me. If you, for example, if you do that, if you promise that I will find your dog if you pay me $100, it becomes very absurd, because there's no surety that you will find my dog. And if you're not able to find my dog, then you get into trouble because you have created a bilateral contract. So that is the difference between a bilateral contract and a unilateral contract. Okay. So again, as we discussed, the logic of this exception to the general rule is the danger of converting it into a bilateral contract. If it is required of you in a unilateral contract that your acceptance must be communicated to me, then at that instance it becomes a bilateral contract. Like I just gave you an example of you finding my lost dog and you communicating your acceptance that you will find my lost dog. It will create it into a bilateral contract. All right, so a little recap of communication of acceptance. So what is the general rule? You know the general rule? It must be communicated to the offerer. And what are the exceptions? If, for example, the offerer has waived the requirement of acceptance, that can be one exception. Another exception can be a postal rule. Acceptance happens at the time it is posted. And the third exception is unilateral contract, where performance of an act or refraining from it is enough to constitute an acceptance. Okay, so let's look at the mode of acceptance. In a contract, an offerer can always stipulate that acceptance is to be made using a specific method. So there are case law on it. The problem that arises is that if the offeree uses another method of acceptance, does this acceptance create a contract? So in that type of cases, the answer is that if the other method used is no less advantageous to the offerer, the acceptance is good. So, and a contract is formed. For example, if I say that I'm that you must communicate your acceptance to me by mail, but you call me on the phone and I pick up the phone and you accept the offer. So it is not less advantageous to me as compared to the method that I prescribe. So this will create a binding contract. So this is the result unless the offeror stipulates a certain method of acceptance and further stipulates that only this method of acceptance is good. So for example, in the same situation, if I say that your acceptance must be posted to me and this is the only way I'm going to accept your acceptance, then if you call me, it will most probably will not create a binding contract, because I have specifically said that this is the only method that I am going to accept. I can have many reasons for it. Maybe I don't pick up my phone. Maybe I just check my mail. There can be many reasons. So if the words of the offer are that clear that this is the only prescribed method, then the offeree should use that method. And if he does not, then the acceptance is not communicated. Okay, so we are also going to look at acceptance by conduct and acceptance by silence. We have already discussed acceptance by word, by writing, and we see acceptance by conduct. It is the problem here is that conduct it's difficult to interpret than written words or speech, right? So that's why you see that the area of case law is in these types of cases, courts have become very creative and they look at the conduct as a whole in order to decide whether there was a contract or not. So there is a case called Brogdon versus Metropolitan Railway. In this case, the mere private act of the railway company in putting the contract in its drawer could not constitute an acceptance because it was not communicated to the coal supplier. However, a contract was eventually found by relying on the conduct of the parties in ordering the coal according to the terms of the agreement and treating it as binding. So the mere act of ordering the coal was a conduct, and it was held to be creating a binding contract. General rule for acceptance by silence is established in the case Feldhaus versus Bingley, and that general rule is that the silence cannot constitute an acceptance. Okay, so in Feldhaus versus Bingley, a nephew and his uncle, it's a case involving a nephew and his uncle, had negotiated the sale of a nephew's horse. They misunderstood each other and became confused about the agreed price. So in a letter, the uncle suggested that they split the difference and that if he heard no more about it, he would consider the sale done for this middle price. The nephew said nothing more to the uncle, but clearly accepted the new price because he told his auctioneer to withdraw the horse from the auction in which it was sold, and as he had already sold it to his uncle. The auctioneer nevertheless sold the horse in an auction by mistake. So it was the auctioneer by mistake sold the horse, and uncle sued him for interfering with his property rights over the horse. Okay. So applying the general rule, can you think of what the court had decided? Did the uncle become the owner of the horse? No. No, silence cannot constitute acceptance, Jennifer. Yes. Saliha, Jeremy. Okay, absolutely right. So it was held that uncle had not become the owner of the horse and therefore had no title to sue, because the contract of sale between the uncle and nephew lacked an acceptance, and so it never existed. So here the rule was, the general rule applied, that acceptance, silence cannot constitute an acceptance. But there are some exceptions to this general rule. In this case that you're looking at, Vital versus Norrell, Lord Steen noted that silence could constitute acceptance in exceptional circumstances. And then he cited another case of Court of Appeal, Russ versus Abbey, where a woman's inaction over 7 months was thought to be sufficient to establish her acceptance of an investment policy taken out on her behalf. So she didn't say anything for over 7 months about that policy, and it was thought that the court held that it was an acceptance. So these are, there are some exceptions to the general rule. Now let's look at some other situations. Okay. So a further related situation can be where the offeree takes the benefit of offered service when he had reasonable opportunity to reject them and reason to know that they were offered with the expectation of compensation. For example, if I see a person washing my car, I did not ask him to wash my car, but I see that he's washing my car, and I know that he expects to be paid for it. Then it becomes arguable whether my silence, I had the reasonable opportunity to reject his services, but you can argue whether my silence constituted an acceptance. Or perhaps the obligation for me to pay should arise from unjust enrichment here, right? I have been enriched, or I have been benefited at the car cleaner's expense through his efforts, and the remaining question is that whether it was unjust. So consider another situation where that person that was washing my car was just giving it a try. He thought that he will wash all the cars in the neighborhood and someone might pay him. So what would happen in that case? Then you can discuss, enrichment is there, but was it unjust? So bring up these kinds of discussions in your exam to score higher. So these are all sorts of things that academics and these have not been discussed much in course, but in academic discussions, there is a lot of discussion on this. So bring up these kinds of issues in your exam when you're writing your exam. Okay. All right. So now finally let's look at the end of an offer. In the last lecture, last week, we discussed rejection of an offer. Of course, that is one way an offer comes to an end, which is very simple. Other than that, there is revocation of an offer. Or another situation can be where a condition is not fulfilled, right? Where the offer is made subject to a condition and that condition was not fulfilled, the offer terminates. And remember, the condition may be implied. It does not have to be explicit always. Another instance of where an offer comes to an end is the death of offerer. And the last one is lapse of an offer. So let's discuss revocation. In the last lecture, we also looked at a formula for agreement. We made a formula for agreement, which was invitation to treat plus offer plus acceptance. It becomes an agreement. Now, a formula for no agreement would be invitation to treat plus offer plus revocation. So that would lead us to no agreement. So now here, notice that revocation comes before acceptance. Okay. So revocation cannot take place after acceptance because once it is accepted, the agreement is already formed, and then an offer cannot be revoked. Okay. Another rule for revocation that you need to keep in mind is that revocation will not benefit from postal rule. As discussed earlier, postal rule does not apply to revocations. It only applies to acceptance. Okay. And yet another rule is revocation does not need to come directly from the offerer. So there can be a third party involved. There's a case on that, Dickinson versus Dodds, where Dodds made an offer to Dickinson that remained open until 12 June. Dodds sold the property he had offered for sale before any acceptance by Dickinson. Okay. And Dickinson heard about this from a third party. Despite this knowledge, Dickinson tried to accept the offer. Dodds refused to transfer the property, and Dickinson sued to enforce the contract. It was held that there was no contract between Dodds and Dickinson. The Court of Appeal thought that the communication by the third party to Dickinson was tantamount to Dodds telling him, "I withdraw the offer." So revocation does not need to come directly from the offerer. Okay. Another issue that was thrown up by Dickinson versus Dodds is the fact that even though the offer is stated to be open until a particular time, it can be revoked before that time. It can be revoked before that time. There is no enforceable promise to keep it open because there is nothing or no consideration given in return for any such promise that I will keep this offer open. There is no consideration, so there is no side contract. Of course, if the offeree pays for it or gives something in return for the promise to keep the offer open, as in the option agreement, the promise to keep it open is then binding. Okay, and where an offer is made to the whole world, for example, let's look at the revocation in that situation, where the offer is made to the whole world or to an indeterminate number of persons at large. Okay. It may be impractical or impossible to communicate the rejection to them all. In that case, it is generally accepted in line. There is a case, an American case, Shuey versus US. So in line with that case, it was a case involving where promise of reward was revoked seven months later. Then it was decided that it is enough if the offerer takes reasonable steps to publicize the revocation. So in these types of cases, the offerer does not need to go to all of the people one by one and revoke his offer. Okay. So these types of cases will generally involve giving the same amount of publicity to the revocation as to the original offer. So if the original offer was an ad, like a poster on in a neighborhood, then revocation must also be posted like that. Same kind of publicity should be given to the revocation. Okay. And it is implicit in such cases that an offer that may be withdrawn by similar method to its initial publication, and Justice Strong in the Supreme Court here in the US said that offeree should have known that it could be revoked in the manner in which it was made. So Shuey versus US is the case that deals with that kind of situation. So in the picture, let's look at the picture from left-hand side. First step, let's assume it's an invitation to treat. The next step is offer. And then comes revocation. So the revocation can only fit in here between offer and acceptance. If you go beyond acceptance, no revocation is possible there. Okay. the case that we just discussed, Dickinson versus Dodd, the offer was open until Friday 9:00 a.m. The facts of the case say that it was open until 9 a.m. Now let's think of a scenario. Had the offer not been revoked and had Dickinson not tried to accept it, then the offer would have lapsed at 9 a.m. because it was stated in the words of the offer that it is open until 9 a.m. So after 9 a.m. it would have been lapsed. We have to keep in mind though that not all offers have specific expiry date and time, right? So what do you think the court would do in this situation? Where there is no specific expiry date and time. Very good, excellent, reasonable time, yes. Sandeep, Jennifer, very good. Okay. And there's a case, Ramsgate Victoria Hotel versus Montefiore. In that case, an offer was made in early June to purchase shares in the hotel company. So Montefiore heard nothing until late November. When he was informed that he had been allotted shares in the hotel company, he refused to accept them. And the court agreed that hotel company's acceptance had come too late because the offer had already expired by lapse of time. Okay. So to recap everything, let's look at a question. It's a long question, so I'll give you some time to read it. So on Monday evening, A tells his three friends, B, C, and D, that he will sell his sports car to the first one to return to him a check of £10,000. B posts a letter on Tuesday evening, enclosing his check, which is delivered to A's home address on Wednesday lunchtime. C calls into see A at work on Wednesday morning and leaves his check in an envelope with A's secretary. Because A is tied up in meetings all day, A's secretary does not pass on the envelope until she next sees B on Thursday morning. B goes to meet A at the station on his way home on Wednesday evening and gives him his check, whereupon A gives B the cards. Which one of the following is true? A, okay. Can you also give me a reason? All of you are saying B validly accepts the offer when he posts his letter on Tuesday evening. But what did he post? Yeah, he posted the check. Okay, so this is a okay, so let's look at the acceptance and consideration. Okay, interesting. It is a little confusing. So I have made it a little too complicated, I guess. So The postal rule here is inapplicable because it is not reasonable in the circumstances to put the risks of delay on the offerer. Okay, the normal rule that actual communication is required applies because A needs to know who is the first to accept in this case. B. What was the option? Let's look at the option B. B's letter becomes a valid acceptance once it is delivered to A's house on Wednesday lunchtime. That's not correct. On these facts, actual communication to A is required, and this does not happen until A gets home in the evening from work. B cannot reasonably expect a posted acceptance to be opened as soon as it is delivered to a home address on a working day. It would almost certainly be different, however, had A gotten home and not bothered opening his mail until the following day. Then it would have been a different case. The first one, yes, Caroline, excellent. Yes, so that was the key word was the first one. Okay, C, B validly accepts when he gives his check to A at the station. That's correct. D has complied with the offer by returning his check to A and has also complied with the basic rule requiring actual communication from which there is no reason to depart on these points. Yes, Afnan, he did not state it. I would let others answer your question. So Afnan is saying that A never stated the mode of acceptance as the post. Yes, yes, you're right. So it would have been unreasonable to use this method. Just keep that in mind. Any other feedback on this? So I got good feedback from Caroline and Afnan that we need to look at. So that means we need to read the questions very carefully and look out for these kinds of traps in the exam. Yes. So postal rule. If it is prescribed that it is acceptance must be posted, or if the offer was in the same kind of form, then it would have been easier to apply the postal rules here. But in this case, it was unreasonable for him to post a letter and cause the delay to A. And okay, good. Yeah, so when there is no mode of acceptance, you have to keep in mind that it has to be a reasonable method of communication. So it should not be less advantageous to the offerer. Yeah, it is. Joel is saying it is very tricky. It is, yeah. And the reason I put this question here is that so that you don't fall into the postal rule trap in your exam. So you have to be quite careful with the postal rules. How about we do a review of postal rule in the next lecture, and then we'll go to our mock exam. We'll do a quick review of the postal rule and other communication, and then we'll go to the next step, which would be a mock exam. Okay, good. All right, so just to reiterate what we discussed in this question, the last one, is that that it was he had to know who was first. So that is, the Caroline picked up the good, the keywords from the question, which is very, very good and excellent. So he needed to know who had accepted it first. So that was the key. So postal rule was, post as a method was not reasonable here. Okay. All right, so an easier one for you. Let's see. Okay, I'm getting answers. A blank to which the postal rule is inapplicable must be communicated prior to the time of acceptance in order to be effective. Good. Very good. Excellent. Revocation. Yeah. Very good. So I'm going to avail this opportunity here to discuss this case very quickly. Henthorn versus Fraser. The revocation was actually posted by 1 p.m. before the acceptance was posted at 3:50 p.m. The revocation was not effective because it only took effect when received at 5:30 p.m. So whereas the acceptance took the benefit of the postal rule and was therefore effective at 3:50 p.m. prior to the receipt or communication of the revocation. So just to clarify, and just to clarify that postal rule does not apply to revocation. Here's the case. So very good, excellent, and thank you very much for your patience.